Hello and welcome. Today we're diving into a really important legal safety net, the law of maintenance. Now, it's got a new home in the Bhartiya Nagarik Suraksha Sanhita, or BNSS, of 2023. This law is a huge deal for so many families, so let's get right into it and make sure it's all crystal clear. So, let's kick things off with a situation that's all too real. What happens if someone who has the money to support their family just decides not to? It's a tough spot to be in, but thankfully, the law doesn't just stay silent. It has a very clear answer, and we're going to unpack it together. Okay, before we jump into the who and the how, we've got to understand the why. What's the whole point of this law in the first place? Let's build that foundation so everything else makes perfect sense. At its heart, maintenance is a pretty simple idea. It's the financial support that the law says one person has to provide to family members who just can't manage on their own. You can think of it as a legally enforced duty of care. Now, this slide gets to the real soul of the law, and the courts have been super clear about this. In cases like Jameer Carr versus Jaswant Singh, they've hammered home that maintenance is a social duty. It's about protecting the vulnerable. And, just as importantly, like in the case of Ahmed Ali versus A. Begum, it is not a punishment. It's an obligation, not a penalty. That's a key distinction. All right, let's get to the main event, Section 144 of the BNSS. This is the section that spells out exactly who can legally ask for this financial support. So, who's on the list? As you can see, Section 144 breaks it down into four main groups. First up, a wife who can't support herself. Second, any minor child who can't take care of themselves. And, importantly, it makes no difference if the child is legitimate or illegitimate. Third, an adult child who has a physical or mental disability that keeps them from being self-sufficient. And finally, a father or mother who is unable to support themselves. So, for a claim to actually go through, three key things have to be true. First, the person being asked for money has to actually have enough means to provide it. You can't get blood from a stone, right? Second, the person asking for help, the claimant, has to prove they genuinely can't support themselves. And third, you have to show that the provider has either neglected or flat out refused to help. And check this out. This is a really important detail, taken word for word from the law. The definition of wife here is really broad, on purpose. It specifically includes a woman who is divorced as long as she hasn't remarried. This is so crucial because it means the responsibility to provide maintenance doesn't just disappear the moment a marriage legally ends. Okay, so now we know who can make a claim. The next obvious question is, how? How does this actually work in the real world? Let's walk through the process step by step. The whole process, from filing the first piece of paper to the court hearing, is laid out in Section 145 of the BNSS. Think of this section as the official rulebook for getting a maintenance claim heard by a judge. Now, to make things easier, Section 145 gives you a few options for where you can file the case. You can file it where the person you're claiming from is, or where you or your wife live. Or, and this is a big one, you can file it where you last lived together. This flexibility is built in to make sure the law is accessible to those who need it most. But this law isn't a one-way street. There are specific situations where a claim for maintenance can actually be denied. Understanding these exceptions is key to getting the full, doubt-free picture. So, this is a major point. A wife could lose her right to maintenance under three very specific conditions. 1, if she's, quote, living in adultery. 2, if she refuses to live with her husband without a really good reason. And 3, if they're living apart because they both agreed to it. But that first one, it brings up a really big question, doesn't it? Yeah, that phrase, living in adultery, what does that actually mean? Does one mistake, one act of infidelity, mean a woman can be cut off from financial support forever? And the answer from the courts in cases like Mahboobi Baby versus Nassar Fareed is a very clear no. They've said living in adultery means a continuous lifestyle, not a single isolated mistake. The right to maintenance isn't lost because of one bad decision. That distinction is absolutely massive. So we've covered the why, the who, the how, and even the exceptions. Now for the final part of the story, the outcome. How much money are we talking about? Can that amount ever change? And what happens if someone just refuses to pay up? The question of how much is obviously a huge one, and the amount isn't just picked out of thin air. To really get the logic behind it, let's look at the story from a landmark 1997 case, Smriti Jasbir Kaur Sehgal. So get this. In this case, the wife of a retired lieutenant colonel needed support. The trial court gave her 1,000 rupees a month. The high court bumped it up a little to 1,500, but then the case went all the way to the Supreme Court, and they ordered 5,000 rupees a month. Why such a massive jump? Here's the key takeaway from the Supreme Court's decision. They said the amount has to be fair, and it has to let the person live a life that's consistent with the family's established standard of living. It's not just about survival. In this case, since the husband was a high-ranking officer, 5,000 rupees was seen as the right amount to maintain that lifestyle. Well, life changes, right? And the law gets that. A maintenance order isn't necessarily set in stone for all time. Section 146 of the BNSS lays out exactly how and why an order can be changed down the road. So a court can change or even cancel an order for a few main reasons. The most common one is a big change in the financial situation of either person. Maybe someone gets a huge promotion or loses their job. Another definite reason is if a divorced wife who's getting maintenance gets remarried. In that case, the order stops. And of course, a ruling from a higher civil court can always change things. Okay, so the court makes an order, but what if the person just ignores it? A court order without any teeth is just a piece of paper, right? Well, that's why the law has enforcement powers built right in, mainly under Sections 144, subsection 3, and Section 147. And believe me, the consequences for not paying are serious. If someone doesn't pay up, the court can issue a warrant to collect the money. If that doesn't work, they can actually sentence the person to jail for up to 1 month for each month they haven't paid. That's a powerful incentive to take the court's orders seriously. And that brings us to our final thought for today. When you look at all of this, you see the law trying to perform this delicate balancing act. On one hand, it's enforcing a fundamental duty to family. On the other, it's trying to be fair to the individual circumstances of everyone involved. It really makes you think, how well does it strike that balance today? And how might it need to evolve for the future? Something to ponder. Thanks for joining me.